Okay, recovery reduced but never barred just by percentage. What's the other type?
The other type is partial or modified comparative negligence. This is actually more common in the states. There are two variations here. In 50% rule states, sometimes called equal fault bar states, the plaintiff can recover with reduction as long as their fault is not greater than the defendant's fault, i.e. 50% or less. If the plaintiff's fault is 50%, they recover 50%. If it's 51%, they recover nothing. In 49% rule states, sometimes called less than states, the plaintiff can recover with reduction only if their fault is less than the defendant's fault, i.e. 49% or less. If the plaintiff's fault is 50% or more, they recover nothing. So under modified systems, if the plaintiff is mostly at fault, they still get nothing. You really need to know which system applies for the bar exam. Absolutely critical to check the question's jurisdiction. And one more crucial point about comparative fault. It generally does not apply to reduce a plaintiff's recovery in cases involving intentional torts by the defendant. The plaintiff's negligence usually isn't a defense when the defendant acted intentionally.
Got it. Now, what about assumption of the risk? How does that fit in as a defense, especially in comparative fault systems?
Assumption of the risk occurs when the plaintiff voluntarily and knowingly encounters a specific, known risk created by the defendant's negligence. Traditionally, like contributory negligence, it was a complete bar to recovery. In most comparative negligence jurisdictions today, however, implied assumption of the risk, where consent is inferred from conduct, is generally merged into the comparative fault analysis. It's treated as just another form of plaintiff's fault that reduces, but doesn't necessarily bar, recovery.
So knowingly skiing down a dangerous slope might just reduce your recovery if the resort was also negligent, rather than blocking it entirely.
In many comparative fault states, yes. However, express assumption of the risk where the plaintiff explicitly agrees, often in writing like a waiver or release form, to accept the risk may still be a complete bar to recovery, provided the agreement is valid and enforceable.
And when are those exculpatory provisions, those waivers, not enforceable? Can you really sign away your right to sue for negligence?
Courts scrutinize these agreements carefully. They generally won't enforce exculpatory clauses if they attempt to disclaim liability for reckless or wanton misconduct or gross negligence as opposed to ordinary negligence. They also might not be enforced if there's a significant disparity in bargaining power between the parties, or if the service involved is considered essential or of great public importance, like medical care. And of course, standard contract defenses like fraud or duress can invalidate them. Plus, they might be void if they violate public policy. 7. Strict liability and products liability, beyond fault.
Okay, we spent a lot of time on negligence, which is all about proving fault, that failure to exercise reasonable care. But now we're shifting gears again into the realm of strict liability, liability without fault. This seems like a totally different animal.
It absolutely is. Strict liability imposes liability on a defendant for injuries caused by their activities or products, even if the defendant exercised the utmost care and was not negligent in any way. Fault is simply irrelevant.
Wow, so you can be held liable even if you did everything right. When does this apply?
It applies only in very specific, limited circumstances where the activity is considered inherently dangerous or involves particular kinds of risks the law believes the actor should bear regardless of fault. For the bar exam, it's helpful to remember the DAD situations for strict liability.
DAD.
D for dangerous activities, abnormally dangerous activities, A for animals, and D for defective or dangerous products. Products liability, which often uses strict liability principles. If the fact pattern doesn't involve one of these three categories, strict liability is almost certainly the wrong answer choice.
Okay, DAD. Dangerous activities, animals, defective products. Let's start with abnormally dangerous activities. What makes an activity abnormally dangerous?
Courts look at several factors, often based on the restatement. Key factors include: does the activity involve a high degree of risk of some serious harm? Is the likelihood that the harm will result great? Is the risk unable to be eliminated by the exercise of reasonable care? Is the activity uncommon in the area where it's being carried on? Is its value to the community outweighed by its dangerous attributes?
So things like blasting with explosives, storing large quantities of toxic chemicals, maybe crop dusting in populated areas.
Those are classic examples. The focus is on the inherent nature of the activity itself, creating a high degree of unavoidable risk, not on the defendant's carelessness in performing it. And importantly, strict liability for abnormally dangerous activities generally only applies to the type of harm that makes the activity abnormally dangerous.
Okay. Next A in DADIA. Animals. Are there different rules for wild animals versus, like, pets?
Yes, definitely. For wild animals, animals that belong to a category not generally domesticated and likely to cause injury if unrestrained, the owner or possessor is strictly liable for all harm done by the animal that results from the dangerous propensities characteristic of that species or propensities the owner knows about. This includes harm caused when someone is injured trying to flee the animal.
So if your pet tiger escapes and mauls someone, strict liability.
Absolutely, even if you had the best cage possible. Now, for domestic animals, pets, livestock, the general rule is no strict liability for injuries they cause.
Oh, so if a dog bites someone.
If a dog bites someone, the owner is typically liable only if they were negligent or if they knew or should have known that the specific animal had dangerous propensities abnormal for its species, like a history of biting. This is often called the one-bite rule, though it's really about knowledge of viciousness. Some states have dog bite statutes that impose strict liability regardless of knowledge.
Okay. What about trespassing animals? If my cows wander onto my neighbor's farm and eat their crops.
Owners of livestock or other animals, except household pets generally, are strictly liable for property damage caused by their animals if they trespass onto another's land. This rule doesn't usually apply to household pets like cats and dogs, unless the owner knows the pet intrudes and causes substantial harm. And if an animal strays onto a public road and causes an accident, the standard is usually negligence, not strict liability.
Got it. What defenses apply generally to strict liability claims? Does the plaintiff's own carelessness matter?
This varies a bit. Traditionally, simple contributory negligence by the plaintiff was not a defense to strict liability. However, a form of assumption of the risk where the plaintiff knowingly and voluntarily encountered the specific danger posed by the activity or animal was often a complete bar to recovery.
And under modern comparative fault systems.
It's mixed. Some comparative fault jurisdictions still don't allow the plaintiff's negligence to reduce recovery in strict liability cases. Others, following the third restatement, do apply comparative fault principles to reduce the plaintiff's recovery based on their percentage of fault, even in strict liability. But knowing assumption of the risk might still be a complete bar, or just reduce recovery depending on the jurisdiction.
Okay. Now, the last D in DD, defective or dangerous products liability, this is a huge area on its own.
It's massive, yes.
Mm.
And claims for injuries caused by defective products can typically be brought under three different theories of liability, which you should always consider: negligence, strict products liability, and breach of warranty.
Let's quickly cover products liability based on negligence first.
This is just applying the standard DBCD negligence framework to the context of manufacturing or selling products. A commercial supplier, manufacturer, distributor, retailer, owes a duty of reasonable care to any foreseeable plaintiff. Users, consumers, bystanders. Breach occurs if they fail to exercise reasonable care in designing, manufacturing, inspecting, or selling the product. Causation and damages, personal injury or property damage, not pure economic loss, must be proven. And the standard negligence defenses, like comparative fault, apply.
Okay, so standard negligence just applied to products. Now the big one, strict products liability. This is where the no-fault idea really comes into play for products.
Exactly. This is probably the most common theory for product injury claims today. Under strict products liability, a commercial seller of a product is strictly liable for physical harm caused by a defective product.
Commercial seller. So it doesn't apply if I sell my used lawnmower at a garage sale.
Correct. Strict liability only applies to defendants who are in the business of selling that type of product: manufacturers, distributors, retailers. It doesn't apply to casual sellers or usually to service providers who just happen to use a product as part of their service.
Okay, and what does the plaintiff need to prove?
Three main elements. First, the product was defective when it left the defendant's control. Second, the defect was an actual and proximate cause of the plaintiff's injury. And third, the plaintiff suffered physical harm, personal injury, or property damage. Notice, no need to prove the seller was negligent.
Just that the product was defective and caused harm. What makes a product defective? Are there different kinds of defects?
Yes, three main types of defects are recognized: manufacturing defects, design defects, and warning defects, or failure to warn.
Manufacturing defects sounds straightforward.
It usually is. A manufacturing defect exists when the particular product unit the plaintiff used deviates from the manufacturer's own intended design or specifications. It's an anomaly, a flaw that occurred during production, making it different from and more dangerous than the other identical products.
Like a single soda bottle with a crack in it.
Exactly. Now, design defects are more complex. Here, all the products of that line share the same dangerous characteristic because the design itself is flawed.
So the problem isn't a mistake in making it, but the way it was planned to be made. How do you prove a design is defective?
Two main tests are used. The older consumer expectation test asks, was the product dangerous beyond the extent that would be expected by an ordinary consumer who purchases it, with the ordinary knowledge common to the community?
Seems a bit vague. What's the other test?
The more common test today is the risk utility test, or risk benefit test. This test asks whether the risks posed by the product's design outweigh its benefits or utility. To prove a design defect under this test, the plaintiff usually must also show that there was a reasonable alternative design, RED, available at the time.
Reasonable alternative design meaning.
A safer, economically feasible, and practical design existed that would have prevented or significantly reduced the risk of harm without substantially impairing the product's utility. If such already existed and the manufacturer didn't use it, the product might be deemed defectively designed.
So it's not enough just to say the design was bad. You usually have to point to a better, feasible way it could have been designed.
Exactly. And the third type is a failure to warn defect, or inadequate warning. This occurs when the product has inherent risks that are not obvious to users, and these risks could have been reduced or avoided if the manufacturer had provided reasonable instructions or warnings. The warning needs to be adequate in its content, expression, and placement.
So even if a product is designed and manufactured perfectly, it can still be defective if it doesn't come with proper warnings about hidden dangers.
Precisely. There's no duty to warn about obvious risks, though. For prescription drugs, there's a special rule, the learned intermediary rule.
Learned intermediary.
This rule generally holds that the drug manufacturer satisfies its duty to warn by adequately warning the prescribing physician rather than the patient directly. The doctor is the learned intermediary, expected to convey the necessary warnings and assess the risks for the specific patient. Exceptions exist if the drug is marketed directly to consumers or dispensed without a doctor's involvement.
Okay. What about damages and strict products liability? Can you get purely economic loss?
No. Just like negligence, strict products liability generally only allows recovery for personal injury or property damage. Purely economic loss, like the product, just doesn't work well, causing lost profits, but no physical harm must typically be pursued under a breach of warranty theory. Also, issues like market share liability can come up here for fungible products where you can't identify the specific manufacturer.
And defenses to strict products liability. What can the defendant argue?
Comparative fault principles usually apply, reducing the plaintiff's recovery based on their own negligence, like misusing the product in an unforeseeable way. Simple failure to discover the defect is usually not considered contributory negligence that reduces recovery. Knowing assumption of the risk might still be a complete bar or reduce recovery. Unforeseeable misuse, alteration, or modification of the product by the plaintiff or a third party can also be a defense. Compliance with government safety standards is relevant evidence, but usually not a conclusive defense.
Okay, that's strict liability. Now, we keep hearing that for pure economic loss, you need to use the third theory, breach of warranty. Let's unpack warranties. These sound more like contract law.
They are. Warranties arise primarily under Article 2 of the Uniform Commercial Code, UCC, which governs the sale of goods. They are essentially promises or guarantees made by the seller regarding the goods. And yes, the crucial reminder, if the plaintiff's only loss is purely economic, a breach of warranty claim is often the only viable route.
What are the main types of warranties? I know there are implied ones.
Yes, two key implied warranties arise automatically in many sales by merchants. First, the implied warranty of merchantability. This means the goods are fit for the ordinary purposes for which such goods are used. They have to be of average, acceptable quality.
So a toaster has to be able to toast bread safely.
Basically, yes. Second, the implied warranty of fitness for a particular purpose. This arises when the seller knows the specific purpose for which the buyer needs the goods, and knows the buyer is relying on the seller's skill or judgment to select suitable goods. If the seller provides goods that aren't fit for that particular purpose, this warranty is breached.
Okay, merchantability for ordinary use, fitness for a specific known use. What damages can you get if these are breached?
Breach of warranty allows recovery for personal injury, property damage, and purely economic loss, like loss of bargain or consequential business losses. That's the key difference for economic loss recovery compared to negligence or strict liability.
Who can sue for breach of warranty? Is it just the person who bought the product? Privity of contract?
This is where it gets tricky. The UCC offers states three alternative versions, alternatives A, B, and C, regarding horizontal privity, who besides the immediate buyer can sue. Alternative A, the most restrictive, Typically extends warranty protection only to the buyer's family, household members, and guests, and usually only for personal injury. Alternatives B and C are broader, potentially extending protection to any person reasonably expected to use the goods, with the C potentially allowing recovery for property damage and economic loss as well. You need to know which alternative your jurisdiction follows.
Okay, alternatives A, B, C for privity. What about express warranties?
An express warranty is created when the seller makes an explicit affirmation of fact or a promise about the goods that becomes part of the basis of the bargain. This could be a statement in advertising, a description, or a sample or model. If the goods don't conform to that express warranty, the seller is liable for breach, regardless of fault or negligence.
And defenses to warranty claims. Can sellers disclaim these warranties?
Sellers can disclaim implied warranties like merchantability or fitness, but the disclaimer must meet specific UCC requirements, often needing to be conspicuous and use specific language like as is. Disclaiming express warranties is much harder, as it's often inconsistent with the warranty itself. Importantly, attempts to limit consequential damages for personal injury in the case of consumer goods are generally considered unconscionable and unenforceable. Other defenses like comparative fault, assumption of risk, product misuse, and failure to provide timely notice of breach can also apply, similar to strict liability. 8. Beyond physical harm, reputation, privacy, business torts.
We've covered a lot on physical and property harms, but tort law also steps in to protect less tangible interests, things like your reputation, your privacy, your business relationships. Let's start with defamation, damaging someone's good name.
Exactly. Defamation protects reputation. A plaintiff has a defamation claim if they can prove these elements. 1, the defendant made a defamatory statement. 2, the statement was of or concerning the plaintiff. 3, the statement was published to a third party. And 4, the statement caused damage to the plaintiff's reputation.
Okay, let's break those down. What makes a statement defamatory?
It's language that tends to harm the plaintiff's reputation in the community, diminishing the respect, esteem, or goodwill others hold for them, or deterring others from associating with them. It's judged from the perspective of a reasonable recipient.
Of or concerning the plaintiff.
A reasonable third party receiving the statement would have to understand that it referred to the plaintiff. It doesn't have to name them explicitly if the reference is clear from context.
Published. Does that mean printed in a newspaper?
Not necessarily. Publication in tort law simply means the statement was communicated either intentionally or negligently to at least one third person, someone other than the plaintiff, who understood its defamatory meaning. Repeating a defamatory statement, republication, is generally also publication.
So even just telling one other person counts.
Yeah.
And damage to reputation.
Yes. The plaintiff generally has to show the statement actually harmed their reputation. However, the rules for proving damages depend crucially on whether the defamation is classified as libel or slander.
Libel versus slander. What's the difference and why does it matter for damages?
Libel is defamation embodied in a more permanent form, typically written or printed. Nowadays, this generally includes statements on radio, television, and the internet as well. For libel, the plaintiff can usually recover general damages. Damages presumed to flow from the reputational harm itself without having to prove specific economic loss.
Okay, libel, permanent form, general damages presumed. What about slander?
Slander is spoken defamation or defamation in some other non-permanent transient form. For slander, the plaintiff generally must prove special damages.
Special damages, meaning?
Meaning specific, identifiable pecuniary economic loss that resulted directly from the slanderous statement's effect on third parties' actions toward the plaintiff, like losing a job or a specific contract because of the slander. This can be very hard to prove.
So slander requires proof of actual economic loss, unless, isn't there an exception?
Yes, the big exception is slander.